which is something, this structuring of discretion is something which has found favor with this court. The 7 principles enunciated in Amanullah case, PLD 1990, Supreme Court 1092.
PLD
1990, Supreme Court 1092. Open policies, open plans, transparency, and so on, which this court has held that it is required of every, and of course it was with regards to the powers that the executive exercises. Now these are all administrative powers we are talking about. This law deals with largely, barring, of course, Section 3. There was a question that was raised. I'll address it towards the end. And Section 5, which I will address separately. So insofar as public importance is concerned, this law, in fact, deals with the issues which are important for public, which is the litigants. Secondly, insofar as independence of judiciary is concerned, my lords, there is no external element, which is to say that no other institution which has given any role whatsoever under this act insofar as practice and procedure of this court is concerned. It is all confined within this court. And that alone suffices insofar as the lack of any basis to challenge this act on the basis of violation of any fundamental right, because Article 9, yes, Article 9 as expounded by this court, access to justice and of course independence of judiciary is something which is which every citizen of this country is entitled to. So my respectful submission insofar as maintainability is concerned, these petitions fail on both counts. My lord, in continuum, as far as independence of judiciary is concerned, and I take your lordships to page 6 of this paper book. Starting from Government of India Act 1935, which was the first constitutional order of this country under which federal court rules of 1950 were made. Under Section 214, subsection 1 of Government of India Act, the federal court could make rules but with the prior approval of the Governor General at that time. And in 1950, the Governor General, of course, was neither part of Parliament, there was no constitution, but under the Government of India Act, Governor General wore several hats, and the executive authority vested in him, and of course part of some legislative authority as well. Under the 1956 Constitution, Article 177 read with 3rd Schedule, Part 1, Clause 3, the rules were made with the prior approval of the President. There was not even a mention of any law as far as the 1956 Constitution is concerned. 62. Under 1962 Constitution, Section 60, Article 65 said, subject to this Constitution and the law and with the prior approval of the President.
In 56 Constitution, the rule-making power was contained in 3rd Schedule.
Yes.
Had to be read with Article, I forget.
177.
That said
subject to law and then...
No, that said subject to law, it said subject to Act of Parliament.
Act of Parliament, but I'll address that, which my Lord has just pointed out. I will address, my Lord, that question. My Lord, as far as... Just bear with me, my Lord. Sir, एक second. I'll just... Article 177, I'll read it out, just for clarity. Until other provisions are made by an Act of Parliament. third schedule would apply. And as far as 1956 Constitution is concerned, nothing happened under that Constitution, but the Constitution provision was until an act of Parliament is made with the prior approval of the President.
56 rules were made.
The 56
rules were made under the 56 Constitution.
56 Constitution, an act of Parliament was not made. 56 rules came with the prior approval of the President.
Is there any
so as far as
is there any difference between Act of Parliament and law?
I'll address that question, my lord. This is a question that I've noted. I'll address it. Under the 1962 Constitution, Article 65, subject to the Constitution and the laws, Supreme Court could make rules with the prior approval of the President. And same position. It was same position under the interim Constitution of 1972, which is Article 193.
I'm sorry, my apologies to interrupt, but the question here is surely when Governor General is referred to and the President is referred to, that's the executive branch. The 73 Constitution had the models from going back to 1935 up to 1972. It eschewed the controlling power of the executive branch. So surely the argument there is that the framers of the Constitution expressly were trying to strengthen the independence of the judiciary and at least, if I may use the term, eliminating one particular branch from the equation. So the argument perhaps is the reverse of what you are saying.
No, I'm coming to that. I'm coming to that.
In mind.
No, I have it in mind. I have it in mind. When I went through this, I noticed that the executive branch was removed, but not the legislative branch. So this is the effect of 1973. This is what has happened in Article 199. The executive action was.
It's a pointer in that of the direction in which constitutional law is traveling.
I'll address that. In India, my lords, under Article 145, Clause 1, it is subject to law and with the prior approval of the President, and so is the position in Bangladesh under Article 107, identical to what is in India and what we had.
In the Constitution, these references, when they say subject to approval of the President, is it unilateral discretion of the President, or it is President advised by the Chief Executive, albeit the Prime Minister, whoever that is?
My lord, so if we look at the jurisdictions where we have this position, of course in India, he acts on the advice. And if, for example, under Article 191...
Government has the last say, not Parliament.
Yes. It was, no, my lord,
with a distinction.
Prior approval.
The prior approval of the President means effectively prior approval of the Prime Minister, not the legislature.
Yes.
Okay.
Yes.
You said that in the Indian Constitution also it says subject to law, but that provision doesn't read like that. It's subject to the provisions of the law made by Parliament.
Yes.
So it's not subject to law.
I will come to that when I take you to Article 191. I'll come to that. I'll come to that when I take you to 191.
I'm just clarifying जो आपने argument की है.
My lord.
वहाँ ये नहीं लिखा.
जी when I'll address subject to law, I'll be addressing.
Page 7 page you reproduce.
Page 6 and 7, yes, my lord. Now, in other jurisdictions, in United States, for example, this is 28 U.S. Code, Chapter 131, Section 2071. The rules made by the Supreme Court have to be consistent with the acts of Congress. And the latest development, or later development, is the Constitution Reform Act of 2005 of the United Kingdom. Now, under Section 45 of that act, the President of the U.S. Supreme Court makes the rules, but he's required to consult with the Lord Chancellor and all the bar councils while making the rules of procedure. So this is the progression, or this is how this is the system that we have in place.
2000 UK Act, does that
2005.
2005 UK Act, for example, do the rules have to be placed before the Houses of Parliament, or is there any involvement at all by the legislative branch?
There is none, but
he has to consult.
He has to consult. Now, whether
with other than the Lord Chancellor, who is a dying breed in the sadly in the UK system, but anyway, It's not. Parliament has made the law despite their rule of sovereign legislative supremacy. Parliament itself has said it's got to be totally independent of us.
Yes. And for that, now, I take your lordship to Article 191. Now, this is where I will address what the term law means and what is the scope that this term has, and whether an act of parliament would be actually covered under the term law or not. Or whether we can give it a meaning where an act of parliament would be excluded from the definition of law and everything else would come under the...
Why? I don't even understand this debate. Why is this? What is I couldn't understand the point of counsel. What was he saying, really?
My lord, the counsel was arguing, began by referring to clause 1 of Article 8, where it said that any law or custom or using having force of law, etc., shall not be made, and then clause 2 said that places a limitation.
माने या ना माने, और जो challenges जैसे law and order की सूरत में और दहशतगर्दी की सूरत में पाकिस्तान का सामना है, तो आज भी एक ऐसा जमात जो अवाम का नुमाइंदगी करता है, जब मुआशी हल निकालना भी चाहते हैं तो उस लिहाज से निकालना चाहते हैं जिससे ट्राफिया पे बोझ डाला जाए और अवाम पे बोझ ना डाला जाए। एक ऐसा जमात जो किसान का ख्याल रखता है, जो मजदूर का ख्याल रखता है, जो सफ़ेद पोश तबका का, जो छोटा ताजिर का, जो नौजवानों का, तालिब इल्मों का। और मेरे ख्याल में आज जो पाकिस्तान की सियासत के मैदान में एक ही जमात है जो मौजूदा मसाइल के मुताबिक they say right man for the right job। तो आज अगर पाकिस्तान में एक इकोनॉमिक क्राइसिस है तो इस इकोनॉमिक क्राइसिस का हल एक तो चले, आपने जो इंटरनेशनली जो काम आपने करना है वो तो चलता रहता है, उसमें भी आपको अहलियत चाहिए, मगर कौन पाकिस्तान की आवाम ना सिर्फ नुमाइंदगी करेगा, मगर चाह वो पाकिस्तान का पार्लियामान हो या अक़वाम मुत्तहिदा हो या IMF के बोर्ड मीटिंग हो, वो यह ख्याल रखेगा, वो एहसास करेगा कि मेरा इस फैसला का क्या बोझ पड़ेगा आम आदमी पे। वो कौन सा जमात है जो का भी ये ट्रैक रिकॉर्ड है कि जब हमने 2009 में मईशत के जिम्मेदारी सौंपी गई, हुकूमत की जिम्मेदारी पाकिस्तान पीपल्स पार्टी के पास थी, तो तब भी मुआशी बहरान था, महंगाई का सुनामी था, दुनिया में रिसेशन चल रहा था। पाकिस्तान एक ज़राई मुल्क होने के बावजूद चीनी, गंदम, चावल ये सारे के हम इंपोर्ट्स करते थे। फूड सिक्योरिटी हमारा लॉ एंड ऑर्डर के लिहाज से दहशतगर्दी के, मगर उस सूरत हाल में जब महंगाई था तो वो पाकिस्तान पीपल्स पार्टी थी जिसने बेनज़ीर इनकम सपोर्ट जैसे इनकलाबी प्रोग्राम शुरू किया, इस बात का एहसास करते हुए कि महंगाई है मगर हम इस मुल्क की गरीब तरीन औरतों को लावारिस नहीं छोड़ सकते। वो पाकिस्तान पीपल्स पार्टी की हुकूमत जिसने बहरान को ना सिर्फ समझा मगर फिर कहा इस बहरान से निकल के।
Your arguments, what I could understand from is, rather than violating a fundamental right, this is a beneficial legislation for the litigant, not for me, not for the state. Everyone may benefit by it or none may benefit by it, but there's certainly, you're not taking away anything, that you are stopping a right of appeal, giving a right of appeal. Whether that can be done, that's another argument, constitutional plane, but that could be addressed in 184.3 or under 199, it's an argument. I'm seeing myself sitting in original, otherwise every case will just be filed in the Supreme Court. Don't bother about the High Courts at all. If you read the jurisdiction of 184, can we just read it for my own benefit, because we tend to forget certain words of 184.3. We don't have additional powers, we have lesser powers than the High Courts.
Clause 3, my lord.
Pura padhe.
Ji.
One the government wala hai na?
Should I read 1 and 2 as well?
Yeah,
3 pad do.
3 pad.
3 pad do. Without prejudice to the provisions of Article 199, the Supreme Court shall, if it considers that a question of importance with reference to the enforcement of any of the fundamental rights conferred by Chapter 1 of Part 2 is involved, have the power to make an order of the nature mentioned in the said article.
In other words, which is the said article 199. So the High Court, you don't have to go for a public importance matter. You don't have to go for enforcement of fundamental rights. You can still go to the High Court. Here, we don't have extra powers. We have the same powers as the High Court, but we have two restrictions: public importance and enforcement of fundamental rights. Public importance is variable. Let's stick to fundamental rights. So the power here is not a much larger power. So my reading of the Constitution, a much narrower power than the High Court. High Court may strike down this law, arguably, and then we can sit in 184 as an appeal. Then we have more powers. I don't know. Am I wrong in my understanding?
That's correct, my lord. And my lord, as far as challenge to the vires of this law.
Just to add to that, where a law deals with powers of this court, the Supreme Court of Pakistan, do you think it would be appropriate for the High Court to adjudicate upon it?
My lord, in another proceedings, this is a submission that I had made in other judgment where a specific question was raised, and my submission, respectful submission at that time was that yes, and I maintain that position.
But are you aware there is a judgment of this court which says otherwise?
My lord, now I'm before a full court, so I'd just, based on that, I'd just proceed. My lord.
I know you press for time.
Attorney General, can you explain the word enforcement? It's not the infringement of the fundamental right. It's the enforcement of the fundamental right. So,
public importance with reference to the enforcement. With reference to the enforcement.
Here, fundamental, public importance, fine. Both parties are there. Now, had it been infringement, then you were right that there has to be a right which was infringed. Here, it's more wider. It's enforcement. They are saying that this is a matter which relates to access to justice. So it's an enforcement of that particular right that they're talking about. They're not saying that it's an infringement of the fundamental right. Can you explain, can you expound on that?
My lord. Now, of course, as I said, my lord, I reiterate that yes, access to justice is a right recognized by this court covered under Article 9, and to an extent, yes, it would be a fundamental right. Now, what they had to show was, the burden is on them, while challenging the constitutionality of this act on the basis of lack of enforcement of fundamental right, as my lord has just pointed out, not infringement of right. What they have to show is that this law does not, in fact, enforce this right of access to justice.
No. It's first we are at the threshold of the maintainability. We don't go into whether this is right, whether it is wrong, whether it is enforcement of the fundamental right or it is an infringement. As far as maintainability is concerned, public importance is done. Then we come to this issue of, does the petition that they have filed, does the petition talk about enforcement of the fundamental right or not?
The petitioner, my lord, proceeds on the basis that by way of this act, powers conferred upon the Chief Justice under the Supreme Court rules have been curtailed or taken away, and that then results in this law being unconstitutional. It is not the case here that this act in any way prevents enforcement of any right.
Attorney General, one way of looking at it is the enforcement part, that whatever act has been challenged impedes the actualization of the fundamental rights. So perhaps it's interchangeably talking about infringement, but however uses a different word. So if a citizen comes and says this particular act thwarts or impairs the actualization my fundamental right, I'm coming to the court. So enforcement or infringement might be synonymous. One more thing, I mean, I think the question of public importance also is a threshold entry point. Suppose if we see, don't you think the petitioner will have to show that in order for it to be a question of public importance, there must be apparently that law must be against public interest. But suppose if it's clearly in favor of public interest, does it constitute a question of interest? To become a question of public interest, it must apparently prima facie be something against public interest, and then you say, yes, it's a question. But if it's so obvious that the whole law is in public interest, for example, do you think there's a threshold to that effect, or there isn't any?
My first part of my submission, my Lord, was that the question of public importance, my Lord, when I pointed out that what this law does is it democratizes this institution, brings more transparency, structures the discretion, it actually advances that public interest. And therefore, they fail on that threshold, that count as well. Where
Attorney General,
my Lord.
On my repeated questions, in response to my repeated questions, they conceded very explicitly that this is a good law. It enhances access to justice, and also, speaking for myself, it addresses a very, very big issue of internal and institutional independence. Now, in that context, when this is an admitted fact, the only question whether the Parliament had the competence or not, क्या जो 184(3) की requirements हैं, वो fulfill होती हैं, because there is no enforcement of fundamental.
If that is so, then these petitions have to be rejected on this basis alone, because insofar as legislative competence is concerned, 184(3) cannot be pressed into service.
So taking
if we'll let you, I think a lot of questions are coming up. We'll note. I'll try to make a point.
These are, my lord, please.
But अगर आप थोड़ा सा अपना continue रखें, I want to know where you're going. Okay.
Attorney General, if I may ask you a question, is the public interest that Parliament, or for that matter a provincial assembly, remains within the limitations that may be placed by the Constitution on Parliament or a provincial assembly? Is it in the public interest?
My Lord, which fundamental right would it
Not
be
talking of
affected?
fundamental right, I'm talking of public interest.
Of course.
Of course.
Yes.
So therefore, if a law...
Again, happening, which I must, interject. I would, you have agreed with, now here I won't agree with you. I will say it may be unconstitutional, but not within the parameters of 184(3). There may be a lot of unconstitutional things going on in Pakistan, but it won't come within the parameters of 184(3). That is the fundamental point. That's my way of approaching it. Others have different ways of approaching it. So I think आप जरा चलें, फिर आप note कर लें सवाल.
I just this part I just
If I may continue, sorry, if I may continue. It is in the public interest. I'm not speaking of any fundamental right. I'm only speaking of public interest. It is in the public interest you accept, and I think rightly so, that because we have a federal structure, Parliament and provincial assemblies must remain within constitutional limits, right? Whatever those constitutional limits are. So therefore, it seems to me to follow logically that if Parliament makes a law that is ultra vires, or a provincial assembly makes a law that is ultra vires, it is in the public interest to challenge that law. Because if remaining within the constitutional limits is in the public interest, then going beyond those limits and making an ultra vires is surely a breach of public interest. What would you say to that?
that touches upon the legislative competence.
No, I'm talking of public interest.
Yes, but any law, a law cannot be struck down on the basis of just being public.
Where the challenge can be is a separate.
Well, Lord, let's just take a step back. Any law made by any legislature, provincial assemblies or the parliament, would be a matter of public interest and importance. It is a law being enacted. Now, in order to examine that law, in order to assume jurisdiction to examine that law, we have to look at, in the case of Supreme Court, Article 184, and the cases of High Court in 199.
नहीं, आप तो कह रहे हैं ना, मैंने जो नोट किया, हो सकता है मैंने फिर गलत नोट किया हो, आप तो कह रहे हैं कि this challenge fails on both counts.
Yes.
Public interest and this.
जी.
तो मैं अभी सिर्फ public interest पे देख रहा हूँ ना. मैं आपसे पूछ रहा हूँ, I mean, speaking for myself, it seems to me that any law which is ultra vires, whether by parliament, whether by provincial assembly, meaning breaches the limitations, whatever they may be, imposed by the constitution, because the constitution is supreme. It is contrary to public interest. Has to be.
Now, let me just quickly address this, because this is a maintainability issue here, and I want to address that issue here first and foremost. The two conditions provided under Clause 3 or required under Clause 3 are connected. It has to be a matter of public importance with reference to enforcement of fundamental rights. Now, independently, any legislation, any statute, any rule or any regulation would be a matter of public importance or public interest for that matter. Now, in order for this court to assume jurisdiction, now this court does not assume jurisdiction under 184(3) on a legislature, on any law being enacted for want of legislative competence. It has to be ultra vires or violative of the rights, fundamental rights granted.
So you say that the word relating to enforcement,
with reference to the enforcement of
that you say is the buckle that connects the two things.
That is the buckle that connects the two, and that is where it actually prevents, if I may say so, this court to examine constitutionality of a statute on legislative competence.
Is legislative competence not in the public interest?
As I said, Your Ladyship, this is something, legislative competence alone is something which can only be examined in 199.
Is it not a right that everyone has under the Constitution
My Lord,
that laws are made in a particular way?
Legislative competence, of course, as I understand it, what you have to see in the act when is an act of parliament, whether Article 70 read with the list permitted it or not, or whether there is a provision of the Constitution which directly confers that power upon the parliament, whether that provision permits it or not. And if those provisions do not permit that legislature to legislate on that particular matter, then yes, this is a legislative competence issue, and it is not permissible under 184.
In your opinion, the law is good law, Parliament is competent to make the law, and every provision of the law is valid and does not in any way violate any provision of the Constitution. So then what happens? Again, I go back to the full court hearing aid, and you have given a right of appeal under that. So are they not then entitled to their right of appeal in the event that the court decides that these petitions are not maintainable? They cannot challenge it? Does that not go to the fact that once again you've put the burden on the court itself to decide when it wants to constitute a full court and block that right of appeal, and when it wants to constitute a smaller bench and allow that right of appeal?
And whether the act is in field or is suspended?
I think my illustrious colleague has raised a very valid point, and I was thinking about it during the break. And if we read the right of appeal, first of all, it talks about an aggrieved person. Now, I'm trying to envisage a scenario where one would be aggrieved. First scenario. Second thing is, we can, and this is permissible, read down legislation. We can, for instance, read into it that wherever there is a full court, needless to say, you cannot have a right of appeal over the full court. So that one can read down the legislation, that those cases. But which right have we determined? What have we taken away from someone? Someone gets an extra right to challenge a judgment. If at all, it's an irritation to us. Oh, now you have the appeal. Oh, now the review jurisdiction has been extended. So what are we doing? And it's not conferring this power to an executive functionary, to the legislature, to the president, or to anybody else. It may be nuisance value for us. Our reviews are going, our appeals are going, that sort of thing. What are we taking away? If the judgment is correct and in order, should we shy away from looking at it because someone files an appeal? Yes, it may bring in litigation into the court. That's the downside, may be said. But where is the aggrieved person? Who will be the aggrieved person be? The person affected. Because I think The 184.3, the whole intendment of that was for not for lawyers. It was not for the well-to-do. It was not for the multinationals. It was for the poor, the dejected of society. We have a whole chapter on the principles of policy, which no one bothers to, we don't read. Bonded laborers, transgender, women rights, children, they can't come to court. We can intervene, 183 can come to their rescue. So I was looking at things in that perspective. We have to see the whole entire constitution as a whole. We just stuck with one provision that somebody says, hey, please tell me how you aggrieved. I kept asking him, are you aggrieved? He says, no. They couldn't do it, you can do it. That's about the argument that I've understood so far. That's a valid argument on its own. Yes, to be addressed, for instance, the income tax ordinance has certain things that have been challenged before the High Court. Could we entertain it on 184.3? After all, it is legislation. After all, it's a public interest. After all, it's a taxation matter. It will meet all the tests of public interest. But it is not, because taxation is not a fundamental right. You can't tax or not tax or whatever. Nobody can say my right not to be taxed has been infringed. So go through the High Court route, get a 191 petition, come to the Supreme Court in 184. That is the appellate jurisdiction. So we should read the Constitution and not just pick the words. We are just stuck with these words, 2 words also. Who's harmed by this? The only thing is you've taken away our power, you've taken away specifically the power of the Chief Justice. That's one irritant. You've given a right. That's another irritant. You have created another same lawyer. Okay, this person wants to waste money on another lawyer, do so. So his power will be lighter. What is it to us?
Mr. Attorney General, if I may, take you back to what you were saying about, and I understand your point, relating to the buckle part of it. So here we have a law which relates to the practice and procedure of the court, and that is, you say you accept that any law which is ultra is against the public interest, but you say the buckle is missing because it's not just legislative competence alone, but it has to do fundamental rights. So I was just wondering.
If I may rephrase it before my Lord formulates the question. Legislative competence cannot be interfered with here.
Oh, no, I'm just saying, I understand that.
Yes.
So he may carry on.
Yes.
But breach of legislative competence is contrary to the public interest. Until it is related to fundamental right, 184.3 cannot be invoked. This is your argument. So I was just wondering that the subject matter of this law essentially is the practice and procedure of the Supreme Court. Article 10A relates to due process. So surely any law relating to the practice and procedure of any court, but let's take the Supreme Court, which is ultra vires, surely that affects due process and therefore is directly relatable to a fundamental right. What would you say to that?
And that is where, when passing this threshold, of course, when a petition comes before your Lordship, so before this court under 184.3, these are the 2 things which are to be examined at the first instance. Now, once this threshold is met, then, and the burden is just discharged.
You Article 10A. It helps sometimes to refresh our memories.
For the determination of his civil rights.
Of his civil right, not the Supreme Court civil rights. Aage padhe.
And obligations, or in any criminal charge against him, a person shall be entitled to a fair trial and due process.
It's nothing to do with the Supreme Court's due process. It's his. You have your right of appeal been taken away, your right of cross-examination been taken away, have your right of a statement under 340 been taken away.
So that's where then it takes me, my Lord, and just addressing your question.
Attorney General, the subject matter is legislative competence in relation to practice and procedure. Surely as a matter of principle, it's not a question of whether the law is taking away. It is this due process in and of itself? And if the law is ultra vires, the answer is precisely because ultra vires, it can't be due process.
So let's proceeding on this.
Whatever it says, whether it says
I'll go with it.
Chief Justice is master of the roster or five.
I'll go with it, and let me just make my submission on this. I'll go with it. When somebody brings in, and let's assume, for the sake of argument, let's assume, and for a moment, if it is assumed that yes, it is a matter with reference to fundamental rights as well, then what has to be shown in the first instance is that this legislation fails to enforce or infringes any of the fundamental rights that the citizens may have.
Well, if due process is interfered with, surely
they have not shown anything to say that there is any due process which they are entitled to under the existing scheme or the scheme as it stood prior to this act.
We made questions. You can continue. I think we have our own views and opinions. Aap chale aage.
Now,
you have to persuade us, not we have to persuade you.
Just one question, I was just thinking about it. Suppose a provincial assembly or even the parliament tomorrow makes a law saying after an appeal has been dismissed under Article 185, another appeal would be available to the litigant before a larger bench. Would that law stand?
I would rather consider these.
Competence ki baat kar raha hu.
Let's consider law did. Maybe tomorrow that very matter comes before us.
So the question is
a second appeal. My Lord's question is whether the second appeal would be provided.
Not at all. I am questioning the competence. The appeal in the Supreme Court under 185 is provided by the Constitution. Can another appeal, which is not specifically provided in the Constitution, be provided by ordinary legislation? The example I gave you was an extreme example. The first question is, can by ordinary legislation an appeal be provided where the Constitution specifically does not against orders passed by the Supreme Court?
I will add to this question. Is there any provision in the Constitution preventing
जो वो टेस्ट है कि जी वो आइटम 55 का कि जी वो हमने तो एनलार्ज किया, पहले एक अपील थी अब हमने दूसरी कर दी है, तो इसलिए ये हमारी कॉम्पिटेंस में है. Would that argument stand?
Noted, my lord.
आप बाद में जवाब दे दें, आगे
ऐड कर रहा हूँ उसमें दूसरी तरीके से. Is there any provision in the Constitution preventing the Parliament from doing so?
Noted, my lord. Now, my lord, if my lord may kindly turn to Article 191. Let's go to Article 191. It has been read out. I'll just read the first part of it, where it says, subject to the Constitution and the law.
Mr. Attorney General, please you read just the preamble of this act and section 3.
Yes. Yes, my lord, it has been read out.
Talks about Article 10A.
Article?
10A.
Yes, it does.
Specifically. And Article 4, Article 25.
My lord.
And subsequently in section 3, specifically talks about 184.3.
My lord.
How this can be proceeded under Article 199 when specifically it is challenging the mandate of the Supreme Court as per section 3 of this act.
My lord.
How that can be moved before the Supreme High Court under Article 199 of the Constitution?
My lord, I noted. My lord, now the question that has come before your lordship is
सुप्रीम कोर्ट प्रैक्टिस एंड प्रोसीजर एक्ट की फुल कोर्ट समाअत जारी है. अटॉर्नी जनरल इस वक्त दलाइल दे रहे हैं. इस मुताबिक मजीद भी अपडेट करते रहेंगे, लेकिन एक ब्रेक के बाद.
ग्लूको टेडी केक जिसमें है मजेदार क्रीमी चॉकलेटी फिलिंग, अंडे, दूध, गंदम की ग़िज़ायत और इजाफी कैल्शियम भी. ग्लूको टेडी. रेडी टेडी ग्लूको.
BOP तकवा बिजनेस अकाउंट, जिससे मिले मुफ्त इंटरबैंक फंड्स ट्रांसफर, ऑनलाइन बैंकिंग, डेबिट कार्ड, चेकबुक, CDR और बेशुमार दीगर सहूलियात। और अकाउंट खुले सिर्फ 1000 रुपए से। BOP तकवा इस्लामिक बैंकिंग, एक यकीन, एक ईमान।
कामयाब मुस्तकबिल को चाहिए यूनिवर्सिटी ऑफ सियालकोट। ADP, BS, MS, PhD प्रोग्राम्स में दाखिले जारी हैं। www.uskg.edu.pk।
आपका हसीन चेहरा, आपकी शख्सियत की पहचान। फायजा ब्यूटी क्रीम, पहचानो खुद को।
रॉयल वॉशिंग मशीन करे आपकी जिंदगी आसान। पावरफुल और बड़े पल्सेटर से मुकम्मल धुलाई, 3-वे वाटरफॉल से कम डिटर्जेंट में ज्यादा कपड़े। इसका मुनफरिद जेट स्ट्रीम करे कपड़ों की 3D रोटेशन वॉश। पावरफुल, ड्यूरेबल मोटर से चाहे जितने ही कपड़े हों ये चलती जाए। और रॉयल ड्रायर कपड़ों को करे इंस्टेंट ड्राई।
वाह, इतने साफ। ये तो रॉयल वॉशिंग मशीन का कमाल है।
रॉयल, साथ जिंदगी भर का।
केजोला और किसान, खुद कफील पाकिस्तान।
परमानेंट मैग्नेट मोटर से 50% बिजली बचेगी। बदले हवा के रंग, रॉयल फैंस के संग।
फेस फ्रेश ब्यूटी क्रीम, जो फेस फ्रेश वही ब्यूटीफुल।
हम झूम गए हर बार, रंगे मेरे बाल जो झूमे।
Samsol hair color.
सैमसंग।
मेरी पूरी फैमिली के कपड़े धुलते हैं सिर्फ प्रियो से, इसीलिए तो मैं कहती हूँ लाइफ के हर ओ के लिए प्रियो।
अलकबीर ऑर्चर्ड, लाहौर के सबसे बड़े केएस के गोल्डन इंटरचेंज पर वाक़ थीम पार्क और डिज्नीलैंड, वर्ल्ड क्लास कम्युनिटी क्लब और कुशादा मेन बुलेवार्ड। बुकिंग का आगाज सिर्फ 2 लाख रुपए से। अ प्रोजेक्ट ऑफ अलकबीर डेवलपर्स।
DHA मुल्तान तरक्की करेगा तो हमारा बिजनेस भी बढ़ेगा।
4 और 8 मरला के महदूद कमर्शियल प्लॉट्स की बुकिंग के लिए अभी कॉल करें। DHA मुल्तान, द न्यू बिजनेस हब ऑफ मुल्तान एंड साउथ पंजाब।
नेमत बनास्पति घी विटामिन A, D, E से भरपूर, जिसमें बने हर खाने से मिले सेहत और जायका एक साथ। नेमत बनास्पति घी, नेमत का शुक्रिया।
मास्टर रॉयल मैट इमल्शन, जो देता है आपकी दीवारों को रॉयल ट्रीटमेंट। मास्टर रॉयल मैट इमल्शन, दाग ठहरने ही न दे। बड़े ख्वाबों को दरकार है ISAT यूनिवर्सिटी गुजरावाला। ADP और BS प्रोग्राम्स में दाखिले जारी है। मज़ीद मालूमात के लिए www.iisat.edu.pk।
पार्ले 24 कैरेट गोल्ड ग्लीम क्रीम ब्लीच, जो आपके नापसंदीदा बालों को ब्लीच करे। पाकिस्तान की पहली 24 कैरेट क्रीम ब्लीच, जो मेलानिन को कम करे और रंगत निखारे। पार्ले 24 कैरेट गोल्ड ग्लीम क्रीम ब्लीच। यही तो होगा। स्टाइलो, जो चाहूं वो पाऊं।
जियो न्यूज क्लॉक के लिए ताउन किया है।
हाँ, जब स्टाइलो पर लगेगी सेल, यही तो होगा। स्टाइलो, जो चाहूं वो पाऊं।
जियो हेडलाइन न्यूज के लिए ताउन किया है।
एक्स्ट्रा लॉन्ग ऑलवेज के 3 गुना तहफ़्फ़ुज़ से रहो एक्स्ट्रा कॉन्फिडेंट। न्यू ऑलवेज एक्स्ट्रा लॉन्ग।
So सुप्रीम कोर्ट प्रैक्टिस एंड प्रोसीजर एक्ट से आइन की क्या खिलाफ वर्जी हुई? कानून को गैर आइनी कहना आसान है, बता दे कौन सा सेक्शन किस शिक से मुतसादिम है, कौन सा बुनियादी हक मुतासिर हुआ, बुनियादी इंसानी हुकूक की खिलाफ वर्जी हुई तो वही बता दें। फुल कोर्ट में समाअत के दौरान चीफ जस्टिस पाकिस्तान जस्टिस काजी फैज ईसा के दरखास्त गुजार के वकील से सवाल। कहा सुप्रीम कोर्ट ने खुद नोटिस नहीं लिया, अगर पार्लियामेंट ने बहुत जोरदार वार किया होता तो हम खुद नोटिस लेते। जज आइन और कानून के तहत काम करने का हल्फ लेता है, मेरी या आपकी क्या राय है उसकी हैसियत नहीं। सुप्रीम कोर्ट के 15 जजेस पर मुश्तमिल फुल कोर्ट सुप्रीम कोर्ट प्रैक्टिस एंड प्रोसीजर एक्ट की समाअत कर रहा है। तारीख में पहली बार सुप्रीम कोर्ट की कार्रवाई टेलीविजन पर बराह रास्त दिखाई जा रही है। सुप्रीम कोर्ट के 8 रुकनी बेंच ने प्रैक्टिस एंड प्रोसीजर एक्ट पर 13 अप्रैल को अमल दरामद रोका था। सुप्रीम कोर्ट के फैसलों के ताबे होने का नहीं, आइन और कानून के ताबे होने का हल्फ उठाया है चीफ जस्टिस काजी फैज ईसा के रिमार्क्स। कहा मुल्क में मार्शल लॉ भी लगे, इस दौरान फैसले आए, वो मार्शल लॉ दौर के अदालती फैसलों के पाबंद नहीं, कोई और हो तो हो। अगर पार्लियामेंट ने हमारे हक पर वार किया होता हम बहुत से केसेस की तरह उसे उठा लेते। रेकॉर्ड एक्ट केस में अदालती फैसले से $6.5 अरब का नुकसान हुआ। बतौर चीफ जस्टिस उन्हें ऐसा इख्तियार नहीं चाहिए। अगर आप चीफ जस्टिस को ये तमाम इख्तियारात देना भी चाहें तो वो नहीं लेंगे। सुप्रीम कोर्ट में दलाइल देते हुए अटॉर्नी जनरल ने कहा सुप्रीम कोर्ट प्रैक्टिस एंड प्रोसीजर एक्ट अवामी खदशात को दूर करता है। सुप्रीम कोर्ट में जमहूरी अमल का तसलसल और अवाम के हुकूक की हिफाजत है। कानून एक ओहदे के इख्तियारात से मुतल्लिक है जिससे इदारे में जमहूरी तौर पर शफाफियत आएगी। कानून से मुतल्लिक दरखास्तें नाकाबिले समाअत हैं। सुप्रीम कोर्ट प्रैक्टिस एंड प्रोसीजर एक्ट से किसी के हुकूक की खिलाफ वर्जी नहीं हो रही। लाहौर में मुस्लिम लीग नून पंजाब का मुशावरती इजलास, पार्टी की चीफ ऑर्गेनाइजर मरियम नवाज और नायब सदर हमजा शहबाज मकामी होटल पहुंच गए। इजलास में नवाज शरीफ की वतन वापसी की तैयारियों का जायजा लिया जाएगा। पेशावर में MD कैट टेस्ट स्कैंडल की तहकीकात जारी। GIT ज़राए का कहना है कि टेस्ट के लिए बाज़ उम्मीदवारों की मशकूक रजिस्ट्रेशन सामने आई। 9 मशकूक उम्मीदवारों की जानिब से एक ही मोबाइल फ़ोन नंबर से रजिस्ट्रेशन का पता चला। मशकूक उम्मीदवारों में 46 साल की उम्र का शख्स भी शामिल है। जामिया कराची में मुतालिबात की मंजूरी के लिए इवनिंग प्रोग्राम के असातिज़ा की हड़ताल। 5 रोज से क्लासेस ना होने से तलबा परेशान। असातिज़ा का कहना है कि कई साल से मुआवजा अदा नहीं किया जा रहा। वाइस चांसलर का कहना है कि फंड्स की कमी का सामना है। माशी परेशानियों के सबब कई साल से तलबा यूनिवर्सिटीज़ की फीस अदा नहीं कर पा रहे। महरान यूनिवर्सिटी जामशोरों में तालिबात को हरासा करने के इल्जाम में IT शोबे का सीनियर असिस्टेंट मुअत्तल। एंटी हरासमेंट कमेटी ने तालिबात के बयानात रिकॉर्ड कर लिए। यूनिवर्सिटी हुक्काम का कहना है कि मुअत्तल असिस्टेंट का बयान भी लिया जाएगा। भारत ने किशागंगन डैम पर आलमी सालिसी अदालत का फैसला न्यूट्रल एक्सपर्ट फोरम पर चैलेंज कर दिया। अटॉर्नी जनरल न्यूट्रल एक्सपर्ट में पाकिस्तान की नुमाइंदगी के लिए आज वियना रवाना होंगे। किशनगंगा डैम केस में आलमी सालिसी अदालत ने पाकिस्तान की दरखास्त को काबिल समाअत करार दिया था। खैबर पख्तूनख्वा की खातून पुलिस अफसर SSP सोनिया शमरोज ने आलमी अवार्ड अपने नाम कर लिया। इंटरनेशनल इंस्टीट्यूट ऑफ विमेन पुलिस ऑफिसर ऑफ द ईयर करार दिया। बटग्राम में खिदमत अंजाम देने वाली सोनिया शमरोज को बेहतरीन पुलिसिंग और खवातीन पर तशद्दुद की रोकथाम पर अवार्ड दिया गया। और कराची में ओवर 40 ग्लोबल क्रिकेट कप का कल होगा आगाज। पाकिस्तान पहला मैच अमेरिका के खिलाफ खेलेगा। इवेंट में हिस्सा लेने के लिए 8 मुल्कों की टीम्स की कराची आमद। पाकिस्तान टीम की क़यादत मिसबाउल हक करेंगे। अब्दुल रज़ाक, शाहिद आफरीदी और हसन रजा भी एक्शन में होंगे। जियो सुपर के तमाम मैचेस बराह रास्त नशर करेगा।
आज का कड़क चैलेंज, कड़क चाय का कड़क दाम निकाल पाएगा एरियल?
तो हो जाए मुकाबला। नया और पहले से बेहतर एरियल बनाए ज्यादा झाग, जो कपड़ों की तह से निकाले चाय जैसे कड़क दाग, सिर्फ एक धुलाई में।
अहम खबरें ब्रेक के बाद।
गाड़ी से शर्र कीचड़ उछला, शुक्र है मैं बच गई। फेंक दो कुर्ता भाभी, ये दाग नहीं धुलना।
अम्मी करूं धुलाई? क्या? मेरा बोनस ट्राई स्टार बनाए झाग ज्यादा और करे दागों की ऐसी दमदार धुलाई जो इस कीमत में पहले कभी ना आई। वाह क्या बात है बोनस की।
एक बार फिर आपको लिए चलेंगे। सुप्रीम कोर्ट प्रैक्टिस एंड प्रोसीजर एक्ट की बराह रास्त तक समाअत जारी है।
In Dobbs versus some other 2022, I think surely that is settled constitutional law.
My lord,
आप जरा please, if you don't mind,
I have to take your lordship.
आप जरा please proceed further. I mean, we will write a judgment whatever we want to write.
Now, my lord, I will. My learned colleague will be recording the questions, noting down the questions, and I'll respond.
One thing, how I understand this. This is not my statement.
Mr. Rahman knows shorthand.
This is not my statement. This is my understanding. The Act of Parliament can be considered as law as well. But every law cannot be considered as act of the Parliament. जैसे कि आप मिसाल लेते हैं, landlord can be landlord, but owner can be treated as owner as well as landlord. तो इस तरीके से ये जो legislation है, तो Parliament करती है, उसको आप law भी कह सकते हैं, Act of Parliament भी कह सकते हैं, लेकिन जो जजमेंट या केस लॉ से आते हैं या कस्टमरी लॉ होते हैं, उसको आप एक्ट ऑफ पार्लियामेंट नहीं कह सकते, तो इसलिए उसको कन्फाइन किया गया, लॉ किया गया।
कह भी नहीं सकते माय लॉर्ड। और दूसरा एक और इसको जस्ट लेट्स लुक एट इट फ्रॉम अनदर एस्पेक्ट। नाउ 1980 is when these rules were made, and when these rules were made, if I draw your attention to order 11, order 11 को जरा देखिए।
अगर हम बहुत ही पेडेंटिक अप्रोच ले लें,
order 11 माय लॉर्ड,
ये पेडेंटिक अप्रोच ले लें, किसने बनाए? किसने बनाए?
सुप्रीम कोर्ट ने। कब? 1980।
सुप्रीम कोर्ट क्या होती है? नहीं, hang on. If you go into that approach, सुप्रीम कोर्ट क्या होती है? बताइए।
All the chief justice and the judges
sitting at home. No, go ahead. No, but if you're going to go that route, then you can even say these are what is they say Supreme Court can make, not administrative meeting of the judges of the Supreme Court. Where does the Constitution provide for an administrative meeting of the judges of the court? So we don't want to just destroy the entire system of governance. So did we sit in a court of law? Did we pass a judgment? How did these rules get enacted? Did people have a say in the matter? Or 10, 15, 17 people, then all gentlemen got together in a closed room and say, here, where is the concept of an administrative thing? That administrative concept itself is created by the rules. So surely it cannot supplant the Constitution itself. It says the Supreme Court. It's very clear. Now, I am not really understanding. I am only concerned with one and only one thing. What have we taken away from Khwaja Sahab, his client, or any citizen of Pakistan? What have we taken away? What have you taken away? If you've taken away something, we will strike it down. I mean, I don't know why we are having this academic discussion. I really don't understand the point.
My Lord, if I may. Now, there is this provision under this law, and Section 7, for example, application for fixation of urgent matters. Do we not know that there are people who died in prisons, condemned to death before their appeals came up for hearing?
This is our domestic affair.
No, with great respect, my lord, it is not.
It is.
Absolutely not, my lord, with great respect. This is the right of the litigants right here.
From the domestic affair.
My lord, with great respect, it is not.
Resolve this.
It can't possibly.
Learned Attorney General, what if the Chief Justice refuses to call a meeting of the full court and refuses the full court to amend the rules? should the Parliament not intervene in the interest of the litigants? That is exactly what happened.
And here, if my lords may kindly turn to Order 11 of the Supreme Court rules. Order 11 of the Supreme Court rules. I'm just going to take this point forward. Order 11 of the Supreme Court rules. It begins by saying, save as otherwise provided by law. The full court, going by, let's say...
एक मैं आपको इसमें तसादुम दिखा दूं अब मौजूदा रूल्स में जो आइन से तसादुम रखती है, ठीक है? अपील इज अ राइट. Civil petition for leave to appeal is not a right. For an appeal, the rules provide 30 days, which is a right. For a civil petition for leave to appeal, you get lots of time, 60 days. I would say it violates the very concept of the Constitution. Maybe it's a mistake, but the other question would be, can these rules be challenged? I think they can be challenged. If they had a supra-constitutional effect, they can't be challenged. Suppose I refuse to, suppose tomorrow I refuse to fix any bench. What will compel me? At the moment there is a stay order of proceedings, I said, nahin, hum chutti pe jaate hain, hum court hi nahi lagate hain. What will you do? Move a reference against me, that's about all. You can't compel me under any law to do that. So, the object is, there has been a problem, there has been successive addition of cases, we are completely closing our eyes to it. हम 2019 में full court meeting हुई थी, वो भी हम नहीं कॉल कर सकते, वो भी इख्तियार चीफ जस्टिस का है. भाई 2019 से 4 साल गुजर गए हैं, क्यों नहीं मीटिंग कॉल हो रही है? 2019 से उस जमाने में 40,000 केसेस थे, अब उसमें ऐड हो गए 27,000. हमारी मर्जी, हमारा डोमेस्टिक अफेयर है? नहीं, हमारा डोमेस्टिक अफेयर है, पर हम तनख्वाह नहीं लें स्टेट से. हम टैक्स पेयर हमें पैसे देता है, हमें एक काम के लिए पैसे देता है, केस का फैसला करो, ये हमारा काम है और कोई काम नहीं है, बाकी सारे हमारे पेरिफेरल काम हैं. तो ये आप इतने आप उस मेन पॉइंट पे आप नहीं रह रहे हैं, आप भी खिसक रहे हैं उधर, वो भी मेन पॉइंट पे नहीं आ रहे हैं.
My lord, I just
जो आप पढ़ रहे थे कॉन्स्टिट्यूशन ऑफ बेंचेस का, इसको पढ़े ना, ये सेव एज अदरवाइज प्रोवाइडेड बाय लॉ.
जी. सो
तो कोई लॉ था नहीं
जी, उस वक्त नहीं था. रिकग्निशन थी कि लॉ प्रोवाइड कर सकता है कुछ.
नहीं, आपसे ये अभी देखें,
उस वक्त लॉ नहीं था.
अब ये लॉ, क्या ये आपके ख्याल में ये जो 1980 के रूल्स हैं, ये लॉ है?
These are
आपसे simple, are the 1980 rules law, come within the purview of law or
191 की definition क्या आप पढ़ते हैं?
191.
No sir.
No.
These are the rules.
These are the rules. The language says subject to the and the law, the Supreme Court will make rules.
What is the purpose of mentioning save as otherwise provided by law?
Yes. This is the recognition of what Article 191 provided. Now, at that time, there was no statute or an act of parliament which provided for anything, but the full court of this court left it open.
Now the law has been promulgated, and this covers under this provision.
Yes, not just this provision, it is covered under 191. This only recognizes what 191 already.
Mr. Attorney General, then you are excluding all those laws which are made under the delegated powers. You are excluding all those laws which are made under the delegation of the power by the government or the parliament. Delegated legislation.
In what context, my lord?
In the context of definition of law.
Delegated.
There are two primary law and the delegated law. And delegated law includes the rules.
No, we are looking at
the Supreme Court rules are not law.
We are only looking at the language of 191. We are looking at the language of 199 and we are trying to understand what is the term or what is the scope of term law as provided under 191 is.
Yes.
Now, I had taken your lordship through how this provision or the pari materia provision had historically progressed, where in addition to parliament there was a executive as well. That role was taken away, that role was eliminated, but the role of parliament remained. And, my lords, Article 67, which provides for the regulation of the rules of procedure of the houses, there is no such
You have not argued on Article 142 because this is the distribution of legislative power.
Yes.
And Majlis-e-Shura Parliament shall have exclusive powers to make laws
with respect
to any matter in the federal legislative list.
Yes.
And if we go through Article 50, the legislative list, item 57, it is also related to
58.
58.
Yeah.
उसके साथ 55, sorry, 55
yes, it
jurisdiction
is,
and
yes.
power of all courts.
So insofar as Section 5 is concerned, it is entry 55. With respect to other provisions, it is Article 191 read with entry 58.
Article 50, sorry, item
Why is
58.
it not coming under 55? It says enlargement of the jurisdiction of
It
the
does.
Supreme
That's
Court
what I said, sir.
and the conferring up there on a supplemental powers. So it
what
has
I
given us
submitted, sir.
more powers. I have committed a mistake. I've given you an exact example of a Himalayan mistake committed by this court, the record judge. 6.5 billion. Isn't that a big enough mistake for us to understand?
That's exactly what I've submitted. Section 5 is covered under entry 58.
So you are trying to resolve that. Why? I don't know. I mean, they don't argue the case. I don't know why we're not proceeding. We love quoting American presidents. Why don't we quote the American president, which the Supreme Court of America says 20 minutes and nothing more? Now, you are not, please don't take questions. You just hear them, write them down, whatever.
Now, my lord, I just stick to the mission that I had made in the beginning. Mr. Amir Rahman is the person who is recording the question.
जब आप देखें हम आज से सुबह से कोई 150 cases की addition हो गई होगी because of this case. We can hear this case for the next month. No other work will happen in the Supreme Court. If you want this system to collapse, please proceed. Take your time. We won't interrupt. ख्वाजा साहब नाराज हो गए थे, अब आप नाराज हो जाएंगे, मुझे बोलने दे रहे हैं. Points ले हम note करेंगे. हम आपको सुनने के लिए बैठे हैं. आपने इतनी मोटी चीजें दी, हम पढ़ लेंगे इनको.
Now, I just quickly rush through my submissions.
And my question that in Order 11, the use of the word law, or the term law, you think it carries the same meaning as in Article 191?
Yes.
Thank you.
Now, my lord, if leaving this act out of the Article 191 would render part of Article 191 redundant, where it says subject to law. And redundancy cannot be attributed lightly to a statute, let alone a constitutional provision. The judgments are in the paper book. My lord, there was another submission which was made with regards to field being occupied, which is to say that since the rules had been made, therefore the field stood occupied and therefore a law cannot be made. Now, that principle also does not apply, because that principle is only applicable where the powers are coextensive or coterminous. Here, the Constitution specifically says that the rules shall be subject to the Constitution and the law. It can't be. So therefore, the principle of the doctrine of occupied field does not get attracted here. Now, my lord, if I may take your lordships to the individual provisions of the statute before I conclude my submissions. Section 2, my lord. Section 2, as I've already submitted, it endeavors to create more transparency, where the power has been, which was under the rules vested in the Chief Justice, has now been
call it a sharing of the burden.
Sharing of
it's
the burden.
It's a huge burden.
Yes.
Why think of it negatively? Think of it positively.
My lord,
I don't want this burden. I want to share it with my colleagues. So what?
Fantastic, my lord. That ends the matter as far as Section 2 is concerned. Absolutely. And because what it does is...
So I don't trust them? That's the only other way. I can't trust them.
It is in this time when we want the justice system to be more efficient. It actually helps. There are more minds sitting together trying to work out how to make things more efficient and transparent in order to aid the litigants who come before your lordships. And if I may say so, the primary duty and obligation of this court is under Article 185, exercising appellate jurisdiction. 184.3 is rare cases which come before you under 184.3. It is actually the appellate jurisdiction of this court which this court is duty bound to exercise. So anything and everything which advances that objective, that constitutional objective, must be supported, must be upheld. There is no fundamental right which gets offended or violated by advancing this objective. And Section 2 endeavors to do as much.
So if that was the objective, the law would again be changed if at some stage the government or the parliament decides that no, 3 judges are not enough, let's do it by ballot. So you would amend the law accordingly?
My Lord, if I may.
Or let's do it, why 3 judges, why not all 17 sitting and deciding which cases go where?
My Lord, if I may respond to this?
Yes, sure.
My Lord, if the pendency is down to 20,000, absolutely there would be no occasion. But if it goes to 75,000, there might be.
Why not 10?
Zero. But this is what is being sought to be addressed.
You will attend to a matter on that thing. I don't think parliamentarians, we should disparage Parliament all the time. If the situation is that there's no pendency, maybe they would have not come up with this thing. Maybe if the damage caused by various was not done, they would have not come up with this thing. So Parliament doesn't operate in a vacuum. It hears, the government is part of it, opposition is part of it, all these people are part of it. They think and they produce something. Maybe not in the most perfect of things, but we have to, each legislation must be supported unless it's clear-cut violation of the ultra-violence of Constitution, fundamental rights in 184(3). Otherwise, it can be ultra-violence of Constitution 199.
And my Lord, the power remains vested in this court.
But Mr. Attorney General, suppose there is a parliament that is elected in the next general election. On your theory, would that parliament not have the power to repeal this law? Of course. Oh, you see, you are saying this is a law
if it repeals it, yes.
That this is a law affecting having such a salutary effect, it is having this, that and the other. So someone can say, जी पार्लियामेंट का तो पावर ही नहीं है, तो ये लॉ को रिपील कर दें. या फर्ज करें अगली पार्लियामेंट आती है, वो सेक्शन 2 को फारिग कर देती है, वो कहती है जी चीफ जस्टिस का पावर है, वो दैट्स गुड इनफ.
माय लॉर्ड
सकती है. आपसे पूछ रहा हूँ.
जी जी.
देखिए अवान साहब मैं देखें प्लीज, मैं उनको भी रोका था और मैं आपको भी रोकूंगा. मैं इस पे नहीं जाऊंगा, मैं रियलिटी पे जाऊंगा. ये कानून आ गया, अब अगली दफा कोई केस ले आएगा हम वो वाला भी देख लेंगे. मैं ओपिनियंस कभी नहीं दूंगा. आप हमारे या तो एडवाइजरी जुरिसडिक्शन इस्तेमाल कीजिए, हम ऐसे आपको ओपिनियंस नहीं देंगे. आपका काम है अपनी सरकार, अपनी गवर्नमेंट को ओपिनियन देना. हमारा काम है उसको उसकी कॉन्स्टिट्यूशनलिटी वैलिडिटी आप देखें, खत्म. हम आपके ऊपर मफरूजे नहीं डालना चाहते हैं कि क्या होगा. भाई हमें क्या पता क्या होगा, जब आएगा हम देख लेंगे. बहुत सारी चीजें आप कर लें प्लीज इस कानून पे और आगे बढ़ा लें बात को, क्योंकि हम देखिए कोर्ट आप समझ नहीं रहे हैं इसकी अहमियत. हम लोग बैठ के इधर एक कंडीशन गवर्नमेंट में बैठ रहे हैं, लोग कोई जेल में मर रहा है, किसी का केस है. मेरी तो मुझे तकलीफ हो रही है. सुबह से 57,000 है. अब हम छोड़ के जाएंगे 150 और बढ़ जाएंगे, कल 150 और बढ़. आप चला लें 1 महीना केस, हमें क्या फर्क पड़ता है. फर्क इसलिए पड़ता है क्योंकि हम तनख्वाह ले रहे हैं इस गरीब आवाम से एक काम करने के लिए कि उनके केसेस का फैसला कर लें, खत्म. ये बहुत अच्छी डिबेट है, जाके हाई कोर्ट में कर लें चैलेंज, वो आ जाएगा जजमेंट नंबर 94 में. हम बड़े पूरे पावर्स के साथ बैठ के इसको देख लेंगे. आपको पता है आज बेंच बनाने का क्या इशू था, इसके बावजूद के स्टे चल रहा है. मैंने अपने 2 सीनियर कलीग से पूछा कि मैं ये करने जा रहा हूँ, 2 स्टे चल रहा है. अलग बात है आइन कानून पर स्टे चल रहा है, फिर भी कि बात को आगे बढ़ा के किसी खत्म कर लेना, सराह लें कानून को, ये तर्क कर दें. मगर आप अपने दलाइल दें, हम उसका सुन लेंगे और फैसला कर लेंगे. कोई इख्तलाफ करेगा, कोई नहीं करेगा, उनकी मर्जी है. हमें आपको परसुएट करने की कोई जरूरत नहीं. आप हमें परसुएट कर लीजिए और सवाल का जवाब नहीं देना चाहते हैं मत दीजिए, हम आपके खिलाफ कर लेंगे फैसला.
My lord, my learned friend is questions.
No, sorry. I'm not indulging in conjectures. I'm asking you a question in order to understand the principles that you are saying and arguing and submitting before the court.
My lord.
I'm not engaging in theoretical argument.
My lord.
I'm trying to understand the basis on which you are defending the constitutionality of this law. So therefore my question stands. Tomorrow if Parliament were to make this a law and say, let it go back to the Chief Justice in his sole capacity, would that is within Parliament's competence?
My lord, if that is so, if it so happens.
Question. Yes, not conjecture. This is to establish the principle. You accept that?
Absolutely, my lord. Absolutely. It is in Parliament's competence, and if I may say so, my lord. My lord, I have
provided assistance.
I have, as Attorney General. Ji, absolutely. Yes.
Okay. Mr. AG, to your right. Section 2, it's provided that the bench, constitution of the bench. Suppose the bench is constituted. Who will assign the cases to the benches? Still, this power has not been given in this act. Again, there will be...
My lord, the committee determine its procedure, and then it, with regards to how the meetings are to be in this committee itself.
Who will assign the cases that this case will be fixed for this bench? And one thing more, if two members, senior members, comes to the conclusion, say tomorrow the Chief Justice will sit in Quetta registry for 1 month, for 6 months, or for 1 year. Is it possible?
My lord,
what would we do if this situation occurs?
My lord, the committee has to, under subsection 2, after the commencement of this act, the committee had to hold its first meeting for the purposes of determining its procedure, and which would have included when and how the meetings were to be held, and the constitution of benches, etc. But that never happened, because the law was suspended, or well, the bill was suspended before it became an act, which was also, if I may say so with regret, was the first. My lord, this is exactly what, under subsection 2, the committee is to do as the first.
We will regulate through rules. They will regulate this act through rules.
My lord, the committee will determine its procedure much the way the Supreme Judicial Council's procedure has also been made. It's not necessarily, I don't know what their relevance, what their status is, an SRO or as a rule or whatever they call it, but the committee can determine its procedure. It will be a procedure of the committee for the purpose of its functioning. Now, Section 3, my lord. Section 3 is exercise of original jurisdiction by the Supreme Court. Now, there was a question which was raised and which was asked when the petitioners were arguing that the committee is to first see whether the matter is, it has to come before the committee to determine if there is a question of public importance with reference to enforcement of fundamental rights, and if the committee thinks so, only then it will constitute a bench. And there was a question raised from the bench that would this not be an administrative power controlling a judicial function? And my response to that, my lords, is that if it is determined, it is held that it is an administrative function and it cannot be performed in a manner to control judicial powers, then my lords would surely come to the conclusion that this court will never exercise suo motu powers either, because while exercising suo motu powers, it is either previously it was the Chief Justice who first determined whether the matter was of public importance and relatable to enforcement of fundamental rights, and then constitute a bench. This is this tension which my lord had also while authoring rendering judgment.
This doesn't answer the question whether the threshold of 184.3 is to be decided by the committee, as this law suggests, or whether it is the function of the court, whether it's a judicial power. That's the fundamental question, that is this not a judicial power? Because there is a threshold, you say so yourself that there's a threshold. So how can a committee be deciding it? And again, it goes to the fact that if the committee decides that this doesn't meet the threshold, then the person that has filed the petition, they can't challenge that decision?
My question is,
there's a distinction between what is filed under 184 and the suo motu, and that's why, my lord.
My question is, if the Chief Justice, just one person, as a master of the roster, could decide whether to take a suo motu or not, why not a committee?
Yes, and that is why my response was that
further, if providing guarantees, and my only question is, are we not accountable to the litigants?
Absolutely.
The Parliament is the representative of the litigants. If they want to change our procedure because they are not satisfied with our internal or institutional independence, that's their prerogative. And we are there to serve the litigants.
And if I may, my lord.
Normally, you see, the cases would be marked by the Chief Justice, even if it's a 184.3. So I think the question of judicial power is secondary. First comes the constitution of the bench, and then judicial power is going to be exercised. Here we're talking about the constitution of the bench. It doesn't impair any judicial power. The question
Geo News Half Hourly Clock is brought to you by
अभी अपने करीबी रिटेलर या माई टेलीनॉर ऐप से ऑफर लगवाओ।
and
पाकिस्तान की पहली 24 कैरेट क्रीम ब्लीच पार्ले 24 कैरेट गोल्ड ग्लीम क्रीम ब्लीच
and
तुम्हें एक और कप चाय,
एक और कप चाय टपाल दानेदार।
अब सिर्फ 200 रुपए में टेलीनॉर 4G मंथली टीम प्ले ऑफर से मिले 15 GB डेटा फॉर फेसबुक एंड व्हाट्सएप। अभी अपने करीबी रिटेलर या माई टेलीनॉर ऐप से ऑफर लगवाओ।
एक कप और है कितनों का बहाना, एक कप और तुम्हें एक और कप चाय,
एक और कप चाय टपाल दानेदार।
हर मौसम में मेरा चेहरा रहे बिना चिपचिप सॉफ्ट सॉफ्ट। बताओ कैसे? नया पॉन्ड्स लाइट मॉइस्चराइजर हर मौसम के लिए। इसका विटामिन ई लाइट फॉर्मूला जिल्द में फौरी जज्ब होके दे बिना चिपचिप और सॉफ्ट सॉफ्ट स्किन। नया पॉन्ड्स लाइट मॉइस्चराइजर।
Your ladyship says is the chief justice and the judges of the Supreme Court.
184 I'm talking
जी
about.
तो 184 में जो सुप्रीम कोर्ट है, सुप्रीम कोर्ट को जो है वो 176 से फ्लो करेगी।
जी जी।
176 में सुप्रीम कोर्ट का मतलब है चीफ जस्टिस एंड ऑल द जजेस। No single person is the Supreme Court. It's all of you who are the Supreme Court. So while exercising jurisdiction, अब ये हो सकता है कि आप ये कहें कि नहीं ये सेक्शन 3 जो है ये इस तरह से नहीं होगा, इसको हम रीड डाउन करेंगे और कोई भी एक्सरसाइज सारी कोर्ट बैठेगी और वो पहले देखेंगे कि ये थ्रेशोल्ड मीट होता है या नहीं होता है एंड देन कमेटी दैट कुड बी।
Mr. Attorney General, the committee is constituted of 3 members to see whether the case do fall within the ambit of 184(3) or not. The litigant would be invited to argue, or that would be only seen by the members of the committee themselves. If 2 out of 3 comes to the conclusion that it is not a case fit for to proceed with Article 184(3), would it not be defiance of right of audience and the Article 10A and all other due process?
In continuation, and what remedy would be available to him, because this is an administrative order, they cannot be challenged in appeal except the chamber appeal under the rules.
Mr. Attorney General, Section 3 is not actually saying that he's going to dismiss the petition at the administrative side. It's simply saying we look at the petition as the Chief Justice looks at the petition. He looks at it, it says a 184(3) petition, he marks it to a bench. It is not saying there is no consequence. Suppose he thinks there is no question, he'll mark it to some other bench. It doesn't say he'll dismiss the petition as to give a hearing to anybody. This is just to look at the
My lord, ये जो threshold है एडमिनिस्ट्रेटिव साइड पे डे इन डे आउट बेसिस पे हमें क्रॉस करना पड़ता है लिटिगेंट्स ऑन दिस साइड, जहाँ पे ऑब्जेक्शन आ जाते हैं रजिस्ट्रार के कि ये मीटिंग।
What's been happening? Number of 184(3) petitions have come up that the office has put objections. Not the judge, the office.
Yes.
जी, one very low.
बिल्कुल।
ठीक है, उन्होंने objection लगा दी, does not come within a parameter.
चैम्बर अपील में जाना पड़ता है।
They've come to me some of the absolutely ridiculous kind of petitions. ठीक है, they're dismissed in my chamber against an appeal is filed. The fact that you don't make available 184(3) does not mean you can't file a civil suit, does not mean you can't file an FIR, does not mean you can't go to 199, does not mean any other remedy. So this is done every day, we do it. Not 3 judges, 1 assistant registrar in the branch office says not maintainable, उसके खिलाफ अपील आती है। वो कितने लोग सुनते हैं? 1 जज। उसके खिलाफ की अपील है? कुछ भी नहीं है, एंड ऑफ स्टोरी। ठीक है, तो यहाँ वो भी जुरिडिक्शन बढ़ गया है। वो आपने हमें वो असिस्टेंट रजिस्ट्रार के पास हमें दे दिए हैं, उसके पास होना चाहिए असिस्टेंट रजिस्ट्रार के पास, तो रहने दें उसके पास, वो बेशक बेहतर तयन कर लेगा, जो कुछ नहीं होगा वो अपील में होगा। अब तो ये तो बल्कि ज्यादा उसको अहमियत